what if President Trump starts ignoring court rulings? To be clear, that hasn't happened. We bring it up because a lot of President Trump's executive orders have gone to court. And recently, Vice President J.D. Vance has suggested judges don't have the ability to challenge Trump's legitimate power. So what tools do courts have? Well, they can levy fines and find parties in contempt for not following orders. There's also jail time, but that's generally considered toothless according to experts. It would fall to the U.S. Marshal Service, which is under the Justice Department, to enforce a judge's order. And we spoke to a retired federal judge who pointed out,
if Trump wanted to fully not comply, he could direct the Department of Justice not to comply. At that point, you have a full-on constitutional crisis.
Historically, there are two instances of presidents ignoring a court's order. One from 1832, when the Supreme Court found that the Cherokee Nation was an independent political community and didn't have to follow Georgia's laws. President Andrew Jackson ignored that ruling and launched the forced migration of the Cherokee Nation known as the Trail of Tears. Almost 30 years later, President Abraham Lincoln suspended the writ of habeas corpus during the Civil War. Chief Justice Roger Taney declared Lincoln did something only Congress can do. Lincoln disagreed. It was essentially resolved 2 years later when Congress authorized the president to suspend habeas corpus. Nowadays, Congress still exists to intervene, but Republicans faithful to Trump control both the House and Senate, and opposition is unlikely.